Tiffany Edwards.
Morning.
This is date and time set for final settlement conference. People are ready to proceed. There is an offer in this case to plead as charged under prosecutor's deferred, reserving restitution. My understanding is that that offer will be taken and this will be a no contest plea. It's just basically send a police report over to court.
The reason for the no contest plea, Your Honor, obviously from the nature of the charges, there is a potential for civil liability.
All right, very good.
And Ms. Millenbringer had provided me previously with a copy of the police report, and I have no objection to the court reviewing it for purpose of this plea.
May I have her sworn, please?
You raise your right hand. You swear to affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
I do.
You lower your hand. State and spell your name for the record.
Tiffaniedwards.
All right. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of malicious destruction of personal property, 200 to 1,000.
Yes,
Correct. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased if 3 times the value of the property taken or that was destroyed. If that is greater than $2,000, that would become the maximum fine. Do you understand that?
I do.
All right. Do you understand what a no contest plea is?
I do.
All right, let me explain 2 things about a no contest plea to make sure that you understand. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
I do.
All right. Still wish to plead no contest?
Yes.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
I do.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that? You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty or plead no contest?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
I am.
The court has been provided Pittsfield Township Department of Public Safety report for their case number 22-15063. Any objection to the court reviewing that to form the factual basis?
No, Your Honor.
Reviewing the report, one thing that I was looking for is in terms of value, is there a stipulation that it's greater than 200?
For purposes of the plea, Your Honor, yes.
All right. With that stipulation and with the review of the police report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
We're satisfied.
I'm satisfied, Your Honor.
Court will accept the defendant's plea of no contest to this. Defendant is referred to probation for a pre-sentence investigation and report and consideration of restitution. Sentencing in this matter will be
September 13th.
Your Honor, I have to ask this question. Are you still doing Zooms or are these live?
It would be by Zoom. Is that a problem?
I've got a jury trial scheduled that week, Your Honor, and I could probably.
We can give you another day.
Yeah, I can.
That's fine.
October 11th.
That work?
Yep. Wait a minute. Oh, I'm sorry. I'm in November. I started to say the 11th is a Saturday. I'm in November. Hang on. I'll show up on the 11th.
Yeah. I'm here.
Yeah,
So
that-
October 11th.
That's
work?
fine. Yeah,
All right.
that's fine.
Sentencing October 11th, 2023, 9 a.m. That will be via Zoom.
May I just briefly respond?
Yes, you may.
Your Honor, we did meet with the victim today. He told us that he believed defendant was kind of glaring at him in the lobby today. So I just want to ensure that defendant is aware of what contact, no intimidating or threatening behavior means. And I just want to ask the court to remind defendant of those conditions.
Your Honor, I was hoping we wouldn't get into this, and I've confirmed this with security out in the lobby. When my client came in, she went to the window because she wasn't sure where to go in this building. The so-called victim started an incident. He had to be restrained, not physically, but he had to be restrained by the security. I've confirmed that with them. He's the one that started whatever happened out in the lobby.
Okay.
I don't have that information, Your Honor, and given that defendant just took a plea, we no longer have a so-called victim, we have a victim in this case.
All right. Here's what I'm going to do. Ma'am, I would just admonish you to, regardless, I guess, of how it starts, to try to conduct yourself and get yourself out of that situation in a way and not have any contact with the victim in this case. Is that understood?
Very clear.
All right. The other thing is the victim present in the courthouse?
Yes, Your Honor.
Have they left?
Oh, he's here. Well, at least was when I walked up to the podium, he was here.
Do we know?
I can ask Mr. Ronnie.
Okay, please do. Because what I'm going to do is I want him out. I'm going to have you wait. And then once we're assured he's gone, then you can leave the building, okay?
Okay.
Not as a punishment to you, but I'm just looking at not having anything start up front. Okay, so let's check. Yes. So ma'am, you can have a seat. We're good.
Your Honor, she need to stop at probation?
She does need to stop at probation, but I don't want her leaving the
I
court
understand.
right now. Until,
Probation down the hall to the left, you'll see a sign. You need to make an appointment. They do need to do a background. It's part of the process that I discussed. They have to do a background check on you.
Oh, okay. So it's,
Just wait till they say it's okay, and then just
Just
go on.
have a seat in the back.
sure. Well, I can't do anything because. Okay, and where is Fink's other side on his case?
Yeah, she's right there, Your Honor.
Where's she? Oh, there you are. Okay.
I'm not sure what you asked, though. I apologize.
Well, I was wondering where you guys were on yours.
We need you.
Doesn't everybody? All right. Okay, we'll wait.
Assistant Public Defender Calvin Hawthorne, appearing with and on behalf of Alexei Makovic. Mr. Makovic, please state your name.
Alexei Makovic.
Your Honor, we're here at final settlement conference. People are ready to proceed. Defendant is kind of eligible. He was 20 at the time of this, so there will be a plea.
That is a correct statement, Your Honor.
Oh, very good. May I have him sworn?
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, but the truth?
Yes.
And lower your hand. State and spell your name for the record.
Alexei Makovic, Alekseimakovik.
Sir, it is this court's understanding you're going to plead guilty to the charge of assault and/or assault and battery. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, I do.
Still wish to plead guilty?
Yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court order their appearance. You're also giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you are indeed guilty.
yes,
June 21st, 2023, at the location of 2979 Silver Spring Drive, Pittsfield Township, Washtenaw County, State of Michigan. What'd you do on that date involving a Marina Makovic that makes you think that you're guilty?
I pushed her.
All right. Didn't have her permission to do that, did you?
No, I did not.
All right, and you did that intentionally?
Yes,
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is also satisfied, Your Honor.
The court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for pre-sentence investigation and report and consideration of HIDA. Sentencing in this matter will be 9 a.m. That will be via Zoom.
Right down the hall.
All right. Probation's right down the hallway to be on your left. At the, basically the very end of the hallway here. All right. Thank you. Bond will continue. Yep. Are they, is he out of the building yet?
I was discussing that with the
Okay, okay, so what's the problem?
So can I just approach briefly, Ryan?
Yes.
Your Honor, John Vincent on behalf of the defense. Guys, take a date and time set for a settlement conference. However, I do believe we have come to an arrangement where Mr. Carter will plead. If I could have the prosecutor read the offer on the record, or I can do it.
That's correct, Your Honor. If he does plead guilty to this case, he also has a child abuse case in which he will be pleading guilty. Then he has 2 pending felony matters, and those will be reduced to misdemeanors.
Got it. Okay.
That is our understanding, Your Honor.
So he's gonna plead guilty to this case and then
Then on the 16th.
on the 16th, he's before me on the child abuse case.
That's
He's gonna
correct.
Plead guilty on those. Then he's before me on 2 felony charges that are gonna have a reduction in plea.
Presumably at the PCC, yes.
Got it.
That's correct.
When did we set those?
That's the 16th for the child abuse. I don't know when the PCC is at.
We might have set those right after. I think I was waiting on the 16th and then I set them out. The 24th, I bet.
Yeah, 24.
I bet you I said, okay, so I'll be seeing Mr. Carter a bit here. All right. All right. May I have him sworn?
Raise your hand. Do you swear or affirm the testimony you're about to give? Lower your hand.
Sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. Is that correct? That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that? Still wish to plead guilty?
Yes.
And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. Because of that, you're giving up your right to call witnesses to speak to you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today to get you to plead guilty to this charge? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will? And also because you are guilty of this offense? On February 17, 2023, at the location of 3024 Woodland Hills Drive, apartment 28, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date involving an Image Boone?
Grab her by the cheek and smushed her.
Say again?
Grab her by the cheek and mushed her head down.
All right, you didn't have her permission to do that, did you?
No, sir.
And you did that intentionally? And Ms. Boone, what is she to you?
She's ex. She's like.
Okay, okay, you have a dating relationship or an intimate relationship. All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. We can go back to my-
That's satisfied, Your Honor.
Court will accept the defendant's. Court will accept the defendant. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be, what I'm gonna do is I would normally sentence him in August, but I'm gonna push it out after presumably everything's done, and then we may try to combine all of the sentences.
So September 11th is next.
That'll get us there. Sentencing will be September 11th, 2023 at 9. That, I'll put that via Zoom at this point. All right.
It'll be in the afternoon.
At 1, that's right, because we're switching those. 12 o'clock noon. Thank you. All right,
Your Honor, could we address bond?
you may.
Just because he has been in, I think, 63, 65 days, something like that, over 60 days on that bond violation, Your Honor. And given that we're going to be out to September, I know there are other things here in the global resolution. I don't know that there's any particular reason, given the agreement, why he couldn't be given a PR bond or at least released on some sort of bond. Again, Your Honor, we would have no problem with tethers, any other kind of mechanisms by which the court would feel confident.
Well, I don't know that that's going to make much sense to do, only because he's not going to be released on the other matters.
Is he, my understanding, at least from last time, was that this was the only thing holding him in the jail. The felonies, I'm pretty sure he's not, and I don't know about the child abuse.
Using on the other ones.
Yeah. I thought on his felonies, he had some type of,
So one felony.
one felony has a personal.
And he says he has a $500 bond on the child abuse.
Child abuse is a $500 for 5,000, 10%.
Right. There should be 2 felonies, I thought. Yeah. Is it 2 cases or just 1?
I think it's just one, that's all.
You only see 1 case, right?
Well, the felony, I don't see the one. But it has multiple
They
charges.
together.
So you may have more charges.
They together.
Yeah, I think that he's been charged, I believe, with felony R&O and felony fleeing and eluding. I think from the same nexus.
Yeah, and I see that all in one case.
They're all in 1 case. so,
Yeah.
Okay.
Your Honor, that's
Yeah.
correct, but may I address?
Yes.
I'm going to object to any reduction in bond at this point. My understanding is that as of late July, he had his phone privileges revoked, but was continuing to call the victim from other inmates' pins still. So I don't have confidence that if Your Honor does release him, that he is going to follow bond conditions. So I'm just gonna ask that the bond remain the same, at least until he's actually complete on his remaining cases.
He assures me he will absolutely abide by any orders court gives.
He told me that a couple of times.
I know, Your Honor, but he's had a lot of time to think about it, though, Your Honor. He's, and he also understands that there are these felony charges now on him as well. I've come to know Mr. Carter quite well through the course of this case. He is a smart young man. He does plan on going to Washtenaw Community College. He was pursuing the job. He is trying to get his life back in order. And again, he would gladly accept a GPS tether, any other sort of thing that you would have to have, Your Honor, to feel confident that he would return.
Do in this case is the motion for bond reduction, I'm going to deny with this caveat. That is, the court will, upon motion, reconsider this after the 25th. of this month after the final felony cases come through. And may look toward having a PSI done before I would change anything, just so that we're sure where he's at and what he'll be doing. So I'm not saying no, I'm just saying I need more information at this time, and I want everything to go through for Mr. Carter before we do anything.
And what would you need from me, Your Honor, to?
If I just, it doesn't have to be a detailed motion, just some motion after my understanding is he's gonna enter those pleas on the 24th. So
At the
it
P-
just needs to be raised by the 25th, and then we'll try to
All right,
see
so-
and address it.
So after the.
You may want to also, because you had the PD on the other matters, right? You may want to coordinate with the public defenders on those cases so that maybe even at the time, I'll change this date to the 24th.
Okay,
And then that way, maybe they can raise it.
on the record.
Everything can be raised at once it's done there.
All right, I'll contact the PD's office, let them know what happened here today and let them know
Okay.
about that.
So I'm not saying no, I'm just saying let's see where everything's at.
Thank you, Your Honor.
All right? Thank you.